Dear students, welcome to today's session. Today's topic for discussion is the rights and duties of shareholders. In India, if you see, companies are mostly established and governed by Companies Act 2013. And there are basically two types of companies established in India. As you all know, one is public limited company and a private limited company. In India, people prefer to open private limited firm because of fewer restrictions and more benefits as well. Shareholders, they play an important role in a company. So it is very important for a company to look after them, as they should be safeguarded, and time to time proper bonus should be given to them. So a shareholder, commonly we refer them as stockholder as well. Can it be any person or company or any institution that at least owns one share of a company's stock? Because shareholders are company's owners. They reap the benefits of the company's successes in the form of increased stock valuation. So shareholders, they play a very important role in framing and of course getting benefited by the profits of the company. Shareholders are the owners of the company. So now we are going to see what are the different types of shareholders and how this has been differed. Equity shareholders. Equity shareholders are the main stakeholders in a company. And when the time of dividend distribution comes, the preference shareholders would get the first. Because preference shareholders have no voting rights because of their preferred status. They receive fixed dividends larger than those paid to common stockholders. So their dividends are paid before the common shareholders. And if you ask me, the number of shareholders in a company depends upon the type of company which they are opening. For a one-person company, one person is required. For a private limited company, 2 persons are needed. For a public limited company, a minimum of 7 persons are required. So what are the different shareholders' rights available? One is appointment of directors. That is the first right where the shareholders play a very important role in the appointment of directors. So an ordinary resolution is required to be passed by the shareholders for the appointment. Apart from this, shareholders can also appoint various types of directors. One is additional director, second is alternate director, third nominee director. Additional director who will hold the office until the next general body meeting. Alternate director who will act as alternate director for a period of 3 months. Then if the director appointed in case of a casual vacancy in the office of any director appointed in a general meeting in a public company. So apart from this, the shareholders also have the right to challenge any resolution passed for the appointment of a director in the general body meeting. So this is one of the rights of a shareholder. With regard to the legal action against directors, shareholders, they also can bring legal action against the director by the rules laid down in the Companies Act 2013. Let me tell you, the first is any act done by the director in any manner which is prejudicial against the affairs of the company, or any act done which is beyond the law or against the constitution. If there is any fraudulent activity, when the assets of the company are being transferred at an undervalued rate, when there is a diversion of funds of the company. So, all these things or any act done in a malefied manner. So these are all the things where in which the shareholders can also bring legal action against the directors. The third rights and privilege where we can discuss about the appointment of company's auditors. So shareholders, they also have the right to appoint the company's auditor. So under Companies Act 2013, the first auditor of the company is to be appointed by the board of directors. Further, the shareholders at the AGM, at the recommendation of the directors and the audit committee. So the appointment is generally done for every 5 years, and further it can be also ratified by passing a resolution in the AGM. So this is now the rights of shareholders with pertaining to the appointment of directors. Voting rights there. Shareholders, they also have the right to attend and vote at the AGM. Every company registered in India should comply with the provision of Companies Act. So it is mandatory for every Indian firm to hold an annual general meeting once in every year, and the meeting can be held anywhere at the head office of the company or any other place as suggested by the company. At the meeting, there are various mandatory agenda points which are to be discussed, and that includes the adoption of financial statements, appointment or ratification of directors and auditors. So when a resolution is brought by the members of a company, then according to Companies Act 2013, it can only be passed by means of voting by the shareholder. What types of voting are there? One is voting by the showing of hands, voting done by polling, voting done by the electronic means, voting by means of postal ballot. So voting by the showing of hands, every member present in the meeting has one vote. So in this type of voting, shareholders vote just by showing of hands. When it comes to voting done by polling, in this type of voting, the chairman or the shareholders demands for a poll. But in case of differential rights as to voting, a particular class of equity shares may also have weighted voting rights. In terms of voting done by the electronic means, every company who has more than 1000 shareholders has to put up a facility of voting through online means. So every member should be provided with the means of voting of online. Then voting by means of postal ballot. Any resolution in the meeting can also be passed by means of postal ballot. So a shareholder also has a right to appoint proxy on his behalf when he is unable to attend the meeting. Though the proxy is not allowed to be included in the quorum of the meeting in case of voting, but it is allowed by following a procedure mentioned in the Companies Act 2013. So these are all the voting rights of shareholders. Then the next is the right to call for general meetings. Shareholders, they have this right to call for a general meeting, or they have a right to direct the director of a company to go for some extraordinary general meeting. They also can approach the company law board for the conduction of general body meeting if it is not done according to their statutory requirements. Right to inspect registers and books. So as you all know, the main stakeholders of a company are the shareholders. They have the right to inspect the accounts register, also the books of the firm. They can ask questions about the same if they will so. The next right is to get copies of financial statements. Shareholders, they have the right to get copies of financial statements, and it is the duty of the company to send such financial statements to all its shareholders, either in quarterly or an annual statement. Pertaining to the winding up of a company, before the company is wound up, the company has to inform all the shareholders about the same, and also all the credit has to be given to all the shareholders. So these are all the major privileges and rights where the shareholders are entitled to. Other shareholder rights, see, when the sale of any material of any company is done, then the shareholder should get the amount which they are entitled to receive. When a company is converted into another company, then it requires prior approval of shareholders. Also, all the appointments has to be done according to all the procedures, and also auditors and directors have to be done. Right to approach the court is also the right of a shareholder in case of insolvency. So these are all the roles, rights, responsibilities of shareholders. There are other several rights where the shareholders can participate in the general body meeting so they can see and advise on the matters when they feel it is not going good. So they are playing a very important role in the functioning of the company. They have various rights from appointment of directors, auditors, voting rights, having a say when the company is going insolvency. With every right that comes a corresponding responsibility which the shareholders must carry out diligently. So these are all the rights and responsibilities, rights and duties of shareholder. See, many factors determine this, the rights and duties of shareholders, class of securities, or whether it is preferred or common stock. In India, as you see, Companies Act 2013, they have established and governed the companies. So, the company needs to look after them, as the shareholders should be safeguarded, and time to time everything has to be given, proper bonus should be given. But let me tell you the ways to become a shareholder. See, first, the company may issue shares to you, either upon registration with SIC or when the directors and shareholders agree to create new shares. Second, an existing shareholder may transfer their shares to you, which the company must register on their share register. So in India, there are two types of companies, as I already said, where people tend to go with private limited companies where there are fewer restrictions as well. So these are all the rights and duties of the shareholder.